All right, Ms. Rivers, are you ready?
Yes, I am.
Okay, let's get on the record. We are moving forward with what I believe is a non-negotiated plea in 24 SC 002292, which is an accusation that combines two cases. One is a case that was tried a few weeks ago involving defendants Pritchett and Robinson, and Ms. Rielly was and remains a co-defendant in that indictment. Ms. Rielly picked up new charges while she was on bond in that case and has been in custody since she was arrested on those new charges. And I believe this accusation incorporates the parts of those new charges to which Ms. Rielly will be entering a plea, such that her plea today will resolve what I'm calling the old indictment, the Pritchett, Robinson, Rielly, Kalish indictment, but will also resolve the formerly unindicted but now accused charges from the more recent arrest. Is that accurate, and does that make sense? I should probably ask it in the other way around. Does that make sense, and is that more or less accurate, Mr. Kelleher?
Yes, Your Honor, that's accurate and makes sense.
Okay, good. All right, then I know why we're here. Good afternoon, Ms. Rielly. In just a moment, Mr. Hiles, the prosecutor in both your cases, now just one case, is going to put you under oath. Once you're under oath, it's important that you answer his questions and mine truthfully and completely. It is just as important if at any time you are confused by something that someone says, or it's just not going the way you thought it was going to go, that you ask one of your lawyers or me any question that you've got, because at the end, I'm going to ask you if you understood everything. And it's never helpful if at the very end you say, well, 20 minutes ago, this Hiles guy said something and I didn't understand it. So it is not a problem for you to say, stop, could you please explain X? And if you and your lawyer need to speak privately about it, we can make that happen as well. Okay?
Okay.
And there may be nothing you don't understand. I'm not saying you need to be on the lookout, but this is an important event for you and it needs to be something that you understand.
Okay.
All right, Mr. Hiles.
All right. I'm trying to scoot over so you can see me, Ms. Rielly. All right, please raise your right hand to the best of your ability. Do you swear or affirm the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Lauren Marie Rielly.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Um,
Yes, actually, I am on medication.
okay.
So I'm gonna interject here. I may from time to time ask my own questions, and that's okay. You're taking some medicine. Can you tell me just sort of generically what you're taking medicine for? Is it a toothache, or you had surgery, or you're depressed?
Yes, bipolar, mood stabilization, and depression.
Okay. And the medicine that you take for those conditions, is that something you take in the morning or at night or all the time?
I take them both morning and at night.
Okay. The ones that you take in the morning, did you take them this morning?
Yes.
And when you take those medicines, do they make you woozy or drowsy or make the room spin around or anything that disorients you?
No, sir.
Okay. Do you feel like you know why you're here and who's here with you?
Yes.
Okay. Do the medicines tend to have the opposite effect? In other words, they keep you stable and focused?
Yes.
Okay. Have you been taking them on a fairly regular basis since you've been locked up?
Yes, I have.
Thank you.
All right. How old are you?
24.
Okay. And the last question regarding, is there any medications that you normally take that you were not given today?
No.
What is your highest level of education that you have completed?
High school diploma.
Okay. Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are pleading today to counts 1 through 7, robbery, count 8, participation in criminal street gang activity, and counts 9 through 11, each being a possession of Schedule II controlled substance with intent to distribute? Do you understand?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you reviewed the rights that you were waiving with your attorneys prior to entering this guilty plea?
Yes.
Have you had enough time to speak with your attorneys about all of the facts and circumstances known to you regarding the charges in this accusation, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorneys?
No.
Are you satisfied with the services of Mr. Kelleher and Mr. Clement?
Yes.
Okay. This is for the attorneys. Do y'all waive formal reading of this accusation,
So waived.
Mr. Clement?
Waived.
And do y'all waive any and all defects in this accusation, including any with respect to your client's name?
Yes, so waived. Yes, sir.
And I'm going to interrupt again. I'm sorry. Ms. Rivers, did you get entries from both attorneys, or should I get them to get their names on the record?
They didn't put them on the record. I have Mr. Kelleher's name. Are you Mr. Clement?
I am Mr. Clement, yes.
Oh, you got it. Okay, great. I just want to make sure you get credit for being here and on the record as well. So we certainly have Mr. Kelly here, who's always been present on behalf of Ms. Rielly. Mr. Clement, you are co-counsel at this juncture, especially for purposes of sentencing.
Yes, Judge.
All right, thank you.
And Ms. Rielly, have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes, I have.
All right, I'm going to go over those charges on the record. Do you understand that counts 1 through 7 each carry with them a potential sentence of 1 to 20 years for robbery?
Yes.
And do you understand that count 8, participation in criminal street gang activity, carries with it a potential sentence of 5 to 20 years?
Yes.
And do you understand that for each count 9 through 11, possession of Schedule 2 substance with intent to distribute carries a sentence range of 5 to 30 years? Do you understand?
Yes.
Okay. Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or Board of Pardons and paroles, and no one can guarantee you parole? Do you understand?
Yes.
Do you understand that this is a non-negotiated plea, and the state is recommending 20 years to serve 10 years in custody with the balance on probation, with special conditions that you must cooperate and testify truthfully in any criminal matters regarding any co-defendants on this accusation, as well as any other individuals you were arrested with? Do you understand?
Yes.
Okay. And you understand that also the special conditions are that you have no contact with any co-defendants, that you have no contact with any criminal street gang members, and that you refrain from participating in criminal street gang activity. Do you understand?
Yes.
Okay. Do you understand that the court, do you understand that even though your attorney will be making a different recommendation on your behalf, the court does not have to follow the recommendations of the state nor of your attorney, and can sentence you up to the max on each charge and run those sentences consecutive or one after another? Do you understand?
Yes.
Do you understand if you're on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
And do you understand that by taking this plea, this sentence may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts? Do you
Yes.
understand?
Yes.
Okay. Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation of the balance of your sentence? Do you understand?
Yes.
Are you a United States citizen?
Yes.
And do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? Do you understand?
Yes.
All right. Do you understand that this guilty plea may affect your right to vote, your right to obtain employment, or your right to possess or transport firearms. Do you understand?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Okay, I'm going to go through these next rights with you one at a time. They're known as your Boykin rights. Do you understand by pleading guilty, you're giving up the right to trial by jury?
Yes.
Do you understand that by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the right to confront witnesses against you?
Yes.
Do you understand that by pleading guilty, you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Do you understand that by pleading guilty, you are giving up the right to the presumption of innocence?
Yes.
And do you understand that by pleading guilty, you are giving up the right to testify on your own behalf and to present other evidence?
Yes.
Do you understand that by pleading guilty, you're giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes.
And do you understand that by pleading guilty, you're giving up the right to appeal if convicted of these charges after a trial?
Yes.
All right. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Okay. And Judge, I believe the defense is going to ask to take this under first offender. So I'm just going to ask the questions and we'll talk about the rest of that later. Are you asking to take this plea pursuant to the provisions of the Georgia First Offenders Act?
Yes.
And have you ever pled guilty to or nolo contendere to any felony or misdemeanor pursuant to the First Offender Act?
No.
Okay. And have you ever been convicted of a felony?
No.
Have you discussed the benefits, the pros and cons of the First Offenders Act with your attorney?
Yes.
Okay. And do you understand that if you are granted the ability to plead under first offender, that you will have not been convicted of a felony, and then if you successfully complete all the terms of your first offender, you will be able to have that cleared from your record and all of your rights restored. Do you understand?
Yes.
However, if you violate the laws of the state or any special conditions of your sentence, you can be revoked for your first offender can be revoked, and you can be resentenced on each charge up to the maximum. Do you understand?
Yes.
How do you plead to counts 1 through 7 robbery?
Guilty.
How do you plead to count 8 participation in criminal street gang activity?
Guilty.
And how do you plead to counts 9 through 11 possession of Schedule II controlled substance with intent to distribute?
Guilty.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And do you understand that you only have until the end of this term of court to file a motion to withdraw this guilty plea?
Yes.
All right, Your Honor, there are 2 separate incidents involved in this accusation. I'm going to start with the incident that occurred on November 8th of 2019. Were this to go to trial, the facts would show that on November 8th, 2019, Lauren Rielly and her friend Lindsay Kalish were at the apartment of a rapper, Voss Coleman, who goes by the name of Young Bands. While at that apartment complex in Midtown, the girls, Miss Kalish and Miss Rielly, were sent a Snapchat message from a Christian Riggs of several large piles of drugs and cash with an invite to a Halloween party that was located on Wiley Street. Mrs. Rielly suggested to the members or to the individuals that were in that apartment, which also doubled as a music recording studio for members of the YSL criminal street gang. Miss Rielly suggested that they quote unquote hit a lick. at which point Max Pritchett was present along with Voss Coleman. Mr. Pritchett and Mr. Coleman then recruited a Tyrone Robinson to help carry out the robberies. After the robbery was planned, and afterwards, when Mr. Robinson arrived, Miss Rielly drove Lindsay Kalish, Tyrone Robinson, and Max Pritchett to 1040 Wiley Street, which is located in the city of Atlanta, Fulton County, at which time Mr. Pritchett and Mr. Robinson remained in the car, and Miss Rielly and Miss Kalish went into the house to scout out the locations of the drugs. Miss Kalish's cell phone was left in the car with Pritchett and Robinson, and pictures of the drugs and their locations were sent from inside the party from Miss Rielly's phone to Miss Kalish's phone. At which point the girls left the house, or Miss Rielly fled from the house after stealing some of the narcotics herself. And then Tyrone Robinson and Max Pritchett entered the house armed with firearms. There were 7 patrons at that party, those patrons being Holden Carmody, Jackson Heil, Christian Riggs, Christian Hooper, Vikyat Gatani, Noah Walker, and Rebecca Mears, all of which had their personal property taken from them at gunpoint. Mr. Gatani, who was the DJ for the party that night, was pistol whipped with the butt of the weapon several times, causing a fractured skull and severe lacerations in his head. Afterwards, the parties fled the scene in Miss Rielly's vehicle. They went back to Young Band's Midtown apartment. Along the way, they were throwing out the wallets and cell phones that were stolen from these individuals, which were corroborated by the recovery of the cell phones and wallets along the route that the Mercedes fled. The drugs that were stolen were then dumped out onto the bed of Mr. Coleman, and a plan was devised at which Mr. Pritchett and Robinson would sell the drugs, mainly edibles, and give the cut of the proceeds to Miss Rielly and Miss Kalish. This is supported by conversations between Miss Kalish and Miss Rielly on the days after the robbery, before they were caught, through their cell phone extractions, as well as Miss Rielly asking Young Bands for money, and then Miss Kalish following up, inquiring as to where their cut of the proceeds were. All of this having been planned in a YSL studio. Now, afterwards, after this arrest, Mrs. Rielly was granted bond about 70 days after coming into custody for this arrest. She was given special conditions of no contact with known gang members, no contact with co-defendants, and she had to be on house arrest and abide by all of the laws of the state. And then on May 30th, a year from ago, last year, she was stopped by Officer Jay Moore of the Fulton County Sheriff's Office in their drug interdiction unit. She was at the corner of Northside Drive and Marietta Street, and she was in a left turn lane with a MARTA bus to her right. When the light turned green, instead of turning left in the left turn lane only, she sped up and cut off the MARTA bus, almost causing a collision, for which she was pulled over by Officer Moore. She was traveling with another gang member, Mr. Reginald Pierce, who is a YSL member as well as a member of the 9 Trey Gangster Bloods. At which time officer approached and noticed a bag that was in the car. As the Officer Moore was speaking with Miss Rielly, Mr. Pierce fled. And Mr. Pierce was ultimately captured. But when the officers came back, they noticed that the bag that was in the car was no longer there. Officers quickly discovered that it had been placed behind some sort of like concrete pole or column close by. And Lauren Rielly admitted that she had actually taken that bag out of the car and hid it as the officers were in a foot pursuit of Reginald Pierce, who at the time was also carrying a Glock 33 that had been amended to be a fully automatic weapon. The drugs that were inside of that bag were oxycodone. There was over 49 pills of oxycodone. And then there was several, there's about over 120 pressed pills. Half of those pills turned out to be a mixture of acetaminophen and fentanyl. And the other half of those pills ended up being methamphetamine. Now, the weight of that mixture of the fentanyl was 49 grams, and the weight of the methamphetamine mixture or methamphetamine was 39.7 grams, almost 40 grams of methamphetamine.
When you say pressed pills, the analysis of either the detective or maybe some crime lab has been, these were homemade pills. This isn't something that you would have received from a pharmacist.
Yes, so this was this was actually done. The analysis was actually done by the ATF lab.
Okay.
They provided the analysis for me, and yes, and so the pills appeared to be marketed as oxycodone and were replicated as such. And however, they were a mixture of acetaminophen and fentanyl. Some of the oxycodone pills were actually, I guess, manufactured by the pharmaceutical companies. And then what turned out to be meth was pressed pills that on the street would have been marketed as MDMA or ecstasy, but it turned out to be meth once the chemical compound was tested. Now, extractions from Ms. Rielly's cell phone as well as Mr. Pierce's cell phone showed that the pattern of drug distribution, her getting pills, making deals, running drugs for Mr. Pierce, as well as assisting Mr. Pierce's mother in the sale of narcotics. This was not one-off incident where she made a mistake and, was helping to, doing something that she didn't know was wrong, which I think was highlighted by her taking the drugs out of the car as the officers pursued Mr. Pierce. Now, I'm going to say a little more than I do instead of just my sentence recommendation. I have taken her cooperation in both the trial of Tyrone Robinson and Max Pritchett, as well as against other co-defendants, into consideration in making my recommendation. I have also cut her several breaks. The armed robberies have been reduced to robbery, making it parole eligible, as well as the trafficking in both fentanyl and methamphetamine. I have indicted accused as possession of Schedule II with intent to distribute, which again makes it a parole eligible and takes away that mandatory minimum. But I've also taken into consideration the records provided from defense counsel. And in looking at that, there is a retributive aspect to this recommendation, because it seems like everything that happened in the past, there were no consequences whatsoever, regardless what impulsions she was acting on. Several people could have been killed in the first violent home invasion, especially Mr. Gattani, who had a fractured skull. But then you move forward and you're dealing with fentanyl, which kills so easily. And it seems like it's every other day that you hear about a high school kid or even a professional who thinks they are taking a pill that is oxycodone or something of that nature, and it's their last move. All of her actions were incredibly dangerous, not only to herself, but also to the general public at large. And considering what her co-defendants got, I still think this offer of 20 to serve 10 is a incredibly fair and generous deal. And I can't take away the assistance she gave the state, but I cannot overlook her actions with the break she was given when she was granted bail. In unlike Ms. Kalish, she chose a completely different route to not only be around gang members, but to also continue to, push dangerous narcotics through the streets of Atlanta. So that is the recommendation of the state. Now, I believe that Mr. Carmody had wanted to speak. I had sent him the Zoom information.
There are two Carmodys on the call.
Okay.
I don't know if Mr. Carmody as in victim Carmody. I think his parents are on.
Or is Holden Carmody not logged on? If Holden is logged on.
There's a Michael and a Nancy, but that's simply the names that are on there. It doesn't mean that Holden isn't.
Okay.
But I'll let you ask.
Yeah. Michael or Nancy, is Holden logged on?
He is not logged on, and he tried, I think he texted or emailed you, but it was right before this began. And he just became overwhelmed.
That's okay. I'll read a statement into the record.
Okay, thank you.
Perfectly fine. All right, so I think I will, if it's okay, Your Honor, I'd like to read his statement. It is the same one, but it's a different record, so I'd like to read this
I
statement.
don't mind. No, this is a different person, different sentencing.
Yeah. All right, it's dated May 14th, 2024. Victim impact statement of Holden Carmody. It's addressed to the judges and parole boards of Pritchett, Robinson, Kalish, and Rielly. It states, I have been forever changed by the traumatic events of the home invasion and assault conducted and planned by the persons named. The experience occurred several months after I had graduated from high school and immediately pushed me into a flight mode to escape and try to forget the near-death events. I chose to, quote, run, end quote, to an unknown city away from the support of my family, and I attempted to self-medicate by living a fast life with an unhealthy crowd of people. I spent nearly 2 years trying to avoid the feelings and engaged in bad behaviors. I distanced myself from my family. I didn't hold down a steady job and was generally lost. They stole my Invisalign braces, and because I left my home and my established doctors, I couldn't get a new set and proceed with my dental plan. My braces were not strictly for cosmetic reasons, and even if I had tried to renew the treatment plan in California, I didn't have the money to do so and lacked the skill set as a young man to navigate the dental system on my own. Avoiding the dentist and orthodontist has caused me additional and compound oral health problems. I believe it is fair to state that by running and delaying my education plans, college, and removing myself from my family support, I have suffered financially because my life moved off track. Witnessing the brutal violence of a person being beaten with a weapon while crying out for their life is traumatic. The memories can loop in my brain and put me in the form of a panic. There are several triggers that cause me to struggle daily. Since the assault, I struggle with trust in people and in settings. I continue to have a habit of avoiding my back to doors and leaving and feeling that if I had a weapon during the invasion, I would have been safer. This attitude is at odds with my family and is a cause of great distress in our relationship. I have sought counseling at times and know I need something consistent in that regards because I am forever changed and affected by the nightmare of a gun to my head. Sincerely, Holden M. Carmody. and Your Honor, I've spoken with the other victims too. All of the victims have stressed how traumatic of an experience this was, to the point where they are afraid to even address the court. And I know specifically, I've happened to have spoken to Holden, Mr. More than most of the victims. He was very involved, and this really did derail his life for a number of years. I'm not sure. I think it's reflected in his statement, but it not only Holden, but several of the others really stunted their college, and many are struggling to finish out college late, but they're doing it. And Mr. Gattani as well. Mr. Gattani suffered from vertigo for months after this home invasion, and he stressed that there was a point in time where he wasn't sure if he was ever going to be able to walk without a cane, or if he was ever going to be able to drive again, because of the constant dizzy spells that come along with vertigo. And legally, when you are experiencing those symptoms, it's just as if you were having epilepsy. They're going to take your driver's license, and you won't have it until you can show you haven't had those symptoms for a year. So these are long-lasting effects. And the sentence recommendation, I think, is fair, and at least from the state's perspective, is taking into account what she did afterwards, as well as the help, which was a great help, that she provided to the state.
All right, I appreciate you amplifying that. Ms. Jackson, can you share with me the criminal history information you have for Ms. Rielly, please?
Yes, Your Honor. She has 5 cycles. The last arrest was May the 31st, 2023 in Fulton County for abandonment of certain dangerous drugs and tampering with evidence, and 3 counts of trafficking cocaine and misdemeanor obstruction of an officer and possession of marijuana with the intent to distribute. Some of those charges were dismissed. The abandonment of certain dangerous drugs and the tampering with evidence and the obstruction of an officer in possession of marijuana with the intent to distribute. They were dismissed on May the 30th, 2024. But that was, seemed like that trafficking may possibly still be pending, Your Honor. There were no convictions listed in the GCIC, nothing in addition.
All right, thank you, Ms. Jackson. This is our last hearing for the day, so I appreciate your support throughout the day. You are free to go.
Thank you. Have a great day.
You too. Mr. Keller here. However you want to divide this up, presentation, whatnot, it is the defense's turn.
So I'm gonna, I guess, start with the most recent thing and kind of work backwards. The 5 cycles are all from this case. There was the initial arrest from this back in 2020, the rearrest on the warrant that was issued based on the bond violation, the arrest for the charges that she's pleading to. She was given bond on that. There were then new charges based on that same incident that were not part of the original charges. Mr. Clement handled that. That was a separate case at one point, but this is not 5 cycles as in these are 5 different arrests. These are 2 incidents that are the 2 incidents that are present before the court. So I just want that to be clear as far as the history.
Got it.
There's a few things that I want to address regarding the state's position and their argument here at the end. At no point has Ms. Rielly ever kind of underplayed the severity of what happened here, but I do think that it is important to keep it in the context of the situation, and especially the testimony that came out at trial, specifically that, this was a party that the idea to rob came up after they were advertising. I believe the testimony was over $10,000 worth of drugs were present at this time between the THC wax, edibles, the ketamine, all of this was present, which was kind of the impetus for why that went on. That when all of the violent acts, the pistol whipping, the aggravated battery occurred, I don't believe there's any dispute in the testimony that Ms. Rielly was not present in the house or directly witnessed or directly participated in any of that. She had gone inside, she had essentially scouted, she had stolen some drugs from the upstairs, placed them in the jacket, had left and was back in the car, unaware of what was going on inside the house, specifically aware of what was going on in the house. General understanding of what was to occur.
Right. No, I follow you. And I don't in any way have wires crossed thinking that Ms. Rielly was wearing one of the masks and was whacking someone on the head with a gun. I get that 100%. But I also remember that it was unequivocal amongst all the witnesses that it was Ms. Rielly's idea of like, hey, what if we do this?
Not in dispute. She testified that.
I agree.
That was
So
absolutely her position. I just,
Right.
for the purpose of, you know, where does she fit into this? Where does she fit into this relative to the other defendants? We're not asking for anything like Ms. Kalish, who the 15 years probation, 10 weekends. That's not, obviously she has more culpability in both the underlying and the subsequent actions than Ms. Kalish.
sure.
You
And
know,
in defense of, not that I'm adopting it, of the state's recommendation, if you array defendants, this would be the third most severe or second least severe recommendation, which is exactly where I see Ms. Rielly falling. She's not Mr. Pritchett's second home invasion. Someone died in the first one, and yet while on probation for that, he did the second one. Mr. Robinson, one of the two armed gunmen who engaged in the series of armed robberies, was your top two, and they got longer sentences. This recommendation is somewhere between Robinson, who is tiered a little below Pritchett, and Kalish, who didn't, after she got bond in this case, get back in the mix. So I don't know that we need to argue a whole lot about where she falls in there. It would be more,
dispute as to that is the right
Okay.
kind of on the hierarchy.
Yes.
It's more of a, is it closer, you know, they're asking for 10, which is kind of directly in the middle between Robinson. We'd be asking for 5, which
Okay.
is closer on the Kalish end,
Yep.
but still substantially more than she got. Still substantially.
A lot more
less
than 10
Robinson.
weekends.
Right, a lot more than 10 weekends, a lot less than 20 years. And we
Okay.
think that there's a number of reasons for that. I'm going to start with the medical issues. These have been provided to the court, the evaluation from Dr. Norman, the impact that those medications, which you've already discussed, that she is now on today, and how that impacted things like her mental health, her impulse control, those issues. I think the record speaks for themselves there as far as the evaluation, so I'm not going to go too much into that.
let me ask about that, though. I don't want to dive deeply into it at all, other than this question, and it relates more to her self-care. What can you share with me, and maybe it's Ms. Rielly who shares it, about the access she had to medication, counseling, et cetera, when she got out on bond from the home invasion case, and was either choosing not to take medication or was saying no thank you to going to a doctor, or it wasn't diagnosed yet. And I didn't
Okay,
pull.
so it was diagnosed. She was on the medications. She had ceased taking the medications because they were having what people at her school were considering adverse impacts on her ability to perform as an athlete, as she was on an athletic scholarship. Those medications have strong tranquilizing effects, early morning practices. There was a push for her to stop taking those at that time.
Okay.
She resumed taking them after she was given bond. She was remaining with treatment and taking medication up from the time she was out on bond, which was December of 2019, up until around October, November 2021. There was a series of issues at home in which she was essentially no longer welcome to be staying at home beginning of late 2021. She was functionally transient for a period of about 5 months there. She was staying with friends, she was staying with boyfriends, she was staying with basically wherever she could at that time. Her situation stabilized sometime after that, but she still no longer had kind of access to medical care and treatment at that point. That continued on, and this was an incredibly tumultuous time in her life. There's documentation in the form of police reports and body camera footage of, specifically an incident in May of 2022 when police came out. She was the victim of domestic violence. She had visible injuries and scarring all over her body. They interviewed her at that time. There's a report that was actually provided to me by Mr. Hiles some number of I guess it'd be over a year ago at this point. But this was an incredibly tumultuous time where she had no real stability or support in that situation. But even while that was going on, she was still actively coming, meeting with me. We were meeting with the state. We had sessions with ADA Parrish, who previously had the case. I guess it was Mr. Hiles at the initial bond hearing, then went to Mr. Parrish. We met with him, an investigator from his office, pursuant to proffer agreements in April of 2022, in June of 2022. After Mr. Parrish left the office, we then, as the case began leading towards trial again, understanding there were other issues, there were delays with the co-defendants there. As we started to begin on trial calendars again, we had meetings with Mr. Hiles and investigators from his office. We had 2 sessions in March of 2022. So we're at a total of 4 sessions at that point. There's then the incident where she's arrested. She's given bond. Your Honor then issued the arrest warrant. Mr. Hiles contacted me, provided me a copy of the arrest warrant. We arranged for her to come turn herself in voluntarily on the morning of June 8th. We then had a brief hearing regarding that. We haven't moved for bond again since then because, essentially we just wanted to reach a point of finality. She understood, I had my chance. I violated that. I don't need to come burden the court's time, burden the state's time. I want to, I understand that I am going to, because of my actions, and especially, once she was back in custody, she's then becoming medicated again. Strong shift in understanding her personality at that point. We did have other things that we've discussed in chambers and in camera in the back. And so we think taking all of these things into consideration, kind of painting the whole picture of this, what is a reasonable sentence for Ms. Rielly? And so that's why we're asking for 20 to serve 5. Same conditions, special conditions. We'd also like to add, to the extent that we can have some kind of mental health treatment or mental health evaluation. I'm not sure if what is available currently through Department of Corrections would be able to address her issues, but that has always been a cornerstone from my nearly 5-year relationship representing Ms. Rielly of what I have observed in her personality during times we were meeting, before, during, after, her decision making, her impulse control. I would like to see that be, to the extent that we can do that, some part of this, because I know that she'll be aged out as far as her parents' insurance and everything by the time any kind of custodial sentence ends. I just don't want, and for the first offender, this is something we had to discuss at great length, because given the number of charges that she's entering a plea to under first offender plea, she's essentially got the rest of, in excess of the rest of her life hanging over her head.
Right.
And, I had grave concerns. I had concerns because of the mental health issues. I had concerns because of what happened during this case about whether or not first offender was going to be a good fit for Ms. Rielly. And, after lengthy discussions there, that was the decision that she made after heavily weighing the potential consequences. And I could not have laid those out in more explicit terms, I think, as far as what she potentially could be looking at. That was the decision that she wanted to make. And so that is why we're asking for that. And I think that really indicates strongly to this court how she sees the future trajectory of her life going.
Okay.
Oh, and Ms. Rielly would like to make an acceptance statement.
I will certainly hear from her. Anything, I don't want to make sure if you wanted to add anything, and it may be it's all been spoken.
I don't have anything additional, Judge. I'm a relative newcomer to this case. Mr. Kelly here is, like you said, it's been nearly
5 years.
5 years, over 5 years. I don't have anything to add. We've talked many times about where we see this case going, and we're kind of there, and that's our joint recommendation.
Okay. Ms. Rielly, I'm going to hear from you in 1 second. If there is something you want to say, Mr. Hiles, I'm assuming that if I accept this plea, we go forward with the plea to the accusation, you will be moving to dismiss or null pros 20 SC 176922 as it applies to Ms. Rielly.
Yes.
Okay. Ma'am.
Okay. Can I'm here today to accept full responsibility for my actions. For any sorrow, pain, or adversity that I have caused, I apologize sincerely. I understand how traumatic the events I participated in could be for the victims, as I would never want anybody I love to go through that as well. I was acting off immaturity and impulsivity. During that time period, I was struggling mentally and did not realize the large impact that this would have on all of our lives. I have learned a lot during my incarceration and should have initially taken accountability for all my actions, including my most recent arrest. I apologize for my involvement with the wrong people as well as my involvement in these wrongful acts. I regret them deeply with a full heart and am prepared to accept the consequences of my actions.
Okay. Well, thank you, Ms. Rielly. Tell me why you think when you get out, because you will get out, this is not a forever sentence. And because of the way Mr. Hiles structured your accusation, the case you're pleading to, you're eligible for parole on whatever sentence I impose. So while you're still young, you'll be out. How are things going to be different so that Mr. Keller here and you aren't back in here and we're talking again about now it's a third time?
Well, I would like to get a proper job, have a proper career. When I was on house arrest, I didn't really get much opportunity to look for a career because I was in college and then I had to, put a hiatus in. I wasn't able to attend. So I'd like to get a proper job. That would be a start. Get a proper home, stability, just try to be a proper citizen of America and do the right thing.
I know it's early and family situations are complicated, but as I said, you will get out at some point. It may seem like a long time from now. It won't be all that long from now. Will you have a place to go when you get out?
Yes.
Or are you going to have to start out wondering, where's the roof I put over my head? And almost immediately you'll be in a stressful, difficult situation.
Yes, my mom said I could stay with her.
Okay.
And Your Honor, Ms. Rielly is present behind me here in the courtroom today.
Thank you for being here, Ms. Rielly. That's great because that's sort of step one when you get out. Too often people are released and they literally get dumped off in the streets where the trouble began. And that's often what repeats itself. Ms. Rielly, I find there is a factual basis for your plea. I'm very familiar with the facts and circumstances of what I'll call part one of your case, the home invasion. And I learned through handling your bond and whatnot, a bit about the second part of your case, the more recent drug business in which you were involved with Mr. Pierce. Is that the right name?
Yes.
Mr. Pierce. So I do think that had you gone to trial, the state could prove all this up. I also find that your plea is knowing and voluntary. Voluntary means that no one's forcing you to do this. And you said as much in your statement that you're accepting responsibility for all this. Knowing means that you've understood the many things that Mr. Hile said, Mr. Keller here has said, and the bit I've said. Is that a fair statement?
Yes.
Any questions about any of the things we've discussed?
No, sir.
All right. Mr. Keller here, can we sign your name to the indictment electronically in the accusation indicating your client's plea?
Yes.
Mr. Hiles?
Yes, Your Honor.
And Ms. Rielly, is it okay if we sign your name on the indictment?
Yes.
We'll do that. I need to talk to you a little bit about first offender. I know you've talked about it a great deal with your lawyers, but you and I have to talk about it as well. First offender is meant to be an opportunity for someone who has not been convicted of a crime before. Your situation is more complicated because this is going to be your first conviction. When I say it's complicated for me, but it's really two different things. And the state easily could have said, we're prosecuting them differently, and you would have had two convictions and could only use first offender on one. But one of the ways in which I think the state is acknowledging some of the steps you've taken to address this, to include your cooperation, is by packaging the two cases into one indictment so that you're eligible for first offender. That means that you wouldn't have legally a conviction. You're going to go to prison. But when you get out and you're on probation, if you're looking for work and you've told me you want a proper job, you don't have to check that box on an application that often means, never mind, throw this away on the application. That's, are you a convicted felon? That's a good thing, but there's risk associated with it. And I can count 250 risks. That's how many years I could sentence you to if I sentenced you to the maximum in this case, 250 years. If I stacked every count on top. I'm not doing that today. And I don't think I'd do that if we had to get back together again because you got first offender and it didn't go well because you hit some stress in your life and you stopped taking medication or whatever the reason is. It really wouldn't matter the reason. If you got arrested again for anything to do with theft or drugs or guns or anything like that, we'd be having a conversation, not about your new charges, but about this case. And I did the math twice, so I think it's right. It's 250 years that I have to work with to say, gosh, Ms. Rielly, we gave you not one, but two chances, two different cases packaged into one, first offender, and things didn't work out. It's just not safe for you or for others for you to be out and about. And you're young, but you're not that young. I could say, hey, 40 years, and then you're not young when you get out. So there's a lot of risk associated with first offender that's not there if you simply plead guilty and this is a conviction. But then it's a conviction and finding a job is harder, among other things, going back to school, et cetera. Do you feel like you've had enough time to think about first offender?
Yes.
And having thought about it and having had your lawyer talk to you forcefully about the risks, what is your position on whether you want to be sentenced as a first offender?
I would like to be. I'm not going to commit any more crimes or be involved with any of that ever again. So I should be able to complete my first offenders.
And why is it that you feel so certain about that right now, that you wouldn't be involved with those kinds of things? Clearly something was attractive to you about the lifestyle that you felt you were participating in with Voss Coleman and Mr. Pritchett and then this Mr. Pierce guy. Why won't that still be kind of alluring to you 6-7 years from now?
Well, this is not fun. This is not a cool lifestyle. This is, I mean,
Being in jail?
Yes, being in jail, but as well as the harm and the traumatics that come with that lifestyle. I don't want to be a part of that anymore. And I'm ready to move forward with my life.
Okay. Ms. Rielly, I'm sentencing you pursuant to the Probation Options Management Act. What that means is that for the portion of your sentence that you are on probation, if you have a minor issue on probation, you and probation can work through that. But if it's more significant, and significant would mean you get arrested for anything, or there's just online information that you're consorting with gang members again, that's going to come back to me. And that's going to be doubly problematic. It's a violation of your probation, but that's the kind of thing that would prompt me, if I decide to sentence you as a first offender, to take away your first offender status, which means resentencing. And if I resentence you, it's not going to be to less time than you've already been sentenced to. It will be to more.
Okay.
All right. I'm going to sentence you on counts. I guess it's all the counts, 1 through 11, to a term of 18 years to serve 8 years with the balance on probation. You have several special conditions. One special condition is that you continue your cooperation with the various authorities with whom you're cooperating. And that doesn't just mean that you talk with them, but that if you're subpoenaed to testify, you provide truthful testimony. You've done that before, you know what that involves, but you need to continue to do that. Second, no contact with any of your co-defendants in either of, I know you're pleading to one accusation, but it's kind of two cases. So no contact with Kalish or Pritchett or Robinson, and then no contact with Pierce or Pierce's mom. Obviously, no contact with any of the victims in the home invasion case. And I know you knew a couple of them. That's how you got the invite. But you don't reach out to them to say, again, I'm so sorry for what happened, or a dumb reason like, I'm going to get you because you guys told the police about what happened. They move forward as best they can while you move forward as best you can, but you don't overlap in any way. I'm going to recommend that when you are on probation, that you be assigned to a mental health probation officer. That's someone who's trained to work with someone who is actively processing a mental health issue. Someone who will know the signs of when you're not taking your medication and know the signs when you are and not be alarmed if you're lethargic and not think, uh-oh, what's she smoking? No, she's not smoking anything. She's taking medication and the side effect is that she behaves a little bit differently. But that's also someone who's going to be on you if you're not taking your medication, because it will also be a special condition of your probation that you need to take any prescribed medication. So if a doctor says you need to take this, you need to take it. It's not optional. If it's giving you strange side effects, then what you do is talk to the doctor to say, we need a different thing. I have a family member who has had to cycle through a variety of medications to treat one of the things you described because of the side effects. And the doctor says, great, we have different ways to come at it. This is the most direct, but it makes you feel terrible. So let's try this one. And you need to handle it the same way. If there's a medication that's disagreeing with you, instead of saying, I'm going to throw those pills away, then you talk to the doctor and say, what's a different way we can address this concern? Understand?
Yes.
All right. I'll also recommend to the Department of Corrections, and all I can do is recommend that you have a mental health evaluation when you get to the diagnostic facility. So you'll go from I think you're at the city jail, but you're in county custody now. You'll go from there to state custody. And all the female inmates go to the same place and they figure out what's the best prison to go to for the remainder of your sentence. And they should do a mental health evaluation, but I have learned, unfortunately, very little information gets transmitted from the county to the state. And so they may have no idea that you've been taking the medication you've been taking. Obviously, you need to pipe up, but if I put on your sentence that I recommend they give you an evaluation, that's just a clue, a signal that they ought to engage with you on making sure your mental health needs are being addressed while you're in state custody. You also, as a special condition of your probation, need to have, I don't think I said this, no contact with any known gang members. So when you get out, you hit Instagram and you maybe feel a little tug of, I remember these guys or this lifestyle, just know that you're violating your probation if in the end it gets reported to Mr. Hiles, hey, check out this social media, and there you are flashing the signs and you're with these guys or gals, it doesn't really matter their gender, but you're back in that mix. That is a surefire way to have your probation revoked, some amount of it. 10 years is a long time on probation, but I'm doing that on purpose because I want to make sure that you get some supervision for a while as you get out, because you'll be making some adjustments. Life will be difficult while you're in custody, but it's also real simple because you don't need to worry about working. You don't need to worry about what your next meal is coming from. And you don't have access to a lot of the temptations and distractions that you'd have when you're out. And I'm going to want to know that for a few years, you've hit a stable spot and we aren't seeing you back in here, but you figured out a way to move forward in a healthy manner that doesn't risk your safety or, equally important, the safety of others like Mr. Carmody or any of the other victims in the case, your case number one. Mr. Hiles, anything else in Ms. Rielly's case?
Nothing further, Your Honor.
Ms. Rielly, I didn't say this. It will happen as a matter of law, but it always helps to hear it from the judge. You'll get credit for all the time you served and both chunks of time. You served a little bit of time before you got your first bond. You served a lot of time since you got rearrested after the second situation. Each one of those days and weeks and months goes towards those 8 years that you need to serve. Okay?
Okay.
Do you have any questions about anything I said?
No, sir.
Mr. Keller here, anything else on behalf of Ms. Rielly?
No, Your Honor.
Okay, I want to thank you for your continued representation. You've helped Ms. Rielly navigate this as best you can. She might have benefited if you rode in the car with her everywhere she went, but you can't do that, and that's not what you were hired to do. But I appreciate your services and your colleagues as he came in later on in the process. And Mr. Hiles, as always, thank you for being prepared in this case. That's it. Yes.
I was actually about
Did
to
you
ask
hear
you that.
Judge, if we could, did you mention whether you were going to sentence her under first offender?
I didn't, and I am.
Okay,
Okay.
just wanted to.
It wasn't meant to be secret. I'm sorry, I didn't mean to leave that hanging. I got focused on a couple of the other things on the list. But it is.
Thank you, Judge.
That's a lot.